Good morning, everybody. I've got a couple folks stuck in the waiting room, so I'm going to slow roll our start today and hopefully get them in here. Well, you know what? That's taking a little bit longer than usual, so I think I'm going to go ahead and get us started. I'm going to start, as I always do, by thanking you guys for joining us today. We're happy to have you here. For those of you that were at the annual conference last week, I'm very sorry that I missed you. I had a family emergency that has been handled, but I was not expecting to miss it. So I'm sorry that I didn't see you all last week, and I hope to hear good stories from everybody about the annual conference. I'm going to take us through our Zoom housekeeping and other reminders like I do every week, and I'll start just by asking you all to stay muted unless you need to unmute yourself to ask a question, which you are welcome to do if you would like to do that once we get started. But otherwise, if you could stay muted, that would be great. Your Zoom toolbar is probably at the bottom of your screen. That's where your video and audio buttons are so that you can mute or unmute and start and stop your video button. You're always welcome, of course, to be on camera or off, whatever your preference and comfort level is. And I did just put a message into the chat like I do every week, directing you to the way to submit questions for each week, as well as to our YouTube channel. So if you submit a question and then you happen to miss a certain week because you're not able to make it, all the videos go up on our YouTube channel so that you can watch them after the fact. It's kind of wild to think that we now have 5 years of content on that channel. So you can go look at 5 years worth of hairstyles or outfits or whatever for all of us. But anyways, that information is in the chat. The chat's also during the Q&A today, the best way to ask us questions or request clarification of something that we're talking about. We do have a lot of questions that were submitted in advance today, so we'll do our best to get through all of them. And if we have time, which I'm sort of doubtful of, but it's not impossible, then we'll try to get to any questions that come from the chat after the ones that were submitted in advance. As we remind you every week, we are not here to give legal advice. So it came to our attention recently that somebody had cited commentary from one of our Zoom Q&A videos in, I think, a bar complaint against another attorney who was doing something they disagreed with. And of course, that never went anywhere. It didn't amount to anything. But that's a perfect example of why we say every week, we are not here to give legal advice. We're just here to talk generally about legal information and developments that we think are newsworthy and helpful to common interest communities and to all of the folks that serve them in Washington State. So when you send us questions that are many paragraphs long or that tell us all about the history of your community or the contents of your bylaws or whatever, those questions are generally too specific. We're going to edit out all the specifics and try to cover the topic generally so that it's helpful and broadly applicable. But again, it's not legal advice. We have been updating you every week on the legislative stuff. Some of our questions are about that, but we wanted to let you know that the legislative session is over. Senate Bill 5129, which is the Wekiwa trailer bill, did pass and has been signed by the governor. And to the extent that that bill revised Wekiwa as it exists now for existing Wekiwa communities, the statutory changes will take effect later in July of this year. To the extent that there are new sections of Wekiwa that will now apply to pre-existing communities, those sections won't take effect until January 1st of next year. And we still have a January 1, 2028 date for the entirety of Wekiwa to apply to pre-existing communities and for the old statutes to go away. Senate Bill 5686 is the foreclosure mediation one. I have had to type those numbers so many times this legislative session, I'm surprised it took me a minute to think of the numbers. That one has also passed both chambers and it's sitting on the governor's desk. We are hoping, I would say without much optimism, that the governor will veto that bill just because of the delays and costs that it imposes on community associations trying to foreclose and collect unpaid assessments. So if you are on the Monday Morning Minute email, you would have received an email this week asking you to consider signing a petition, asking the governor to veto that bill. If you haven't done that yet, please consider doing it. If you haven't received that email, but you would like a link to where you can go to sign the veto, please send an email to info@condolaw.net and I will give Chelsea the link so that she can send it back to you so you can sign the petition to ask the governor to veto that bill. And then in the coming weeks and months, as these new legislative changes take effect and become part of our statutes, we will continue talking to you about, how those all are going to affect our communities. I think that might be it as far as our housekeeping goes. Katie, am I missing anything?
I don't think so.
All right, well then let's go ahead and jump into our questions for this week. The first one is, how often should a community revise or update their governing documents? And the short answer to this question is that there isn't a cut and dry answer that is always true for every community. So you revise them whenever it makes sense to do it for your community. We do recommend, and we tell our clients often, that the board should review and read the documents every year. I don't think most of our clients do it, but we still recommend it, even though we know that most of them don't do it. Because I think that is one way that you can, over time, evaluate the effectiveness of your documents, what changes might make sense for your community. Sometimes you'll find things you didn't even know were in there. And so reviewing them about once a year makes sense to me. And as far as actually revising them, it probably depends on a number of factors, right? How old are your documents? How well or poorly written are they? How many statutory changes have taken effect since your documents were drafted or last amended? I think there's no question that given the really significant changes that are going to be coming down the pike for all common interest communities that are not already governed by WCIOA, this is a really good time to look at your documents and to consider whether restating or even some targeted amendments might make sense for your community. And we do strongly recommend that you look at what your documents say and what WCIOA says and try to identify some of the differences so that you can, number one, understand what parts of your documents are no longer going to be enforceable. And number two, so that you can understand what practices you are going to have to change when WCIOA for all takes effect. Again, as a reminder, for most of that statute, we're not looking at until January 1st of 2028. However, Senate Bill 5129 that passed this legislative session does have a revised meetings section that will take effect January 1 of 2026, and that section is going to apply to everybody early. So that probably feels like a lot to as a layperson, open up really dense, hard to read governing documents and then really dense, sometimes hard to read statutes and figure out what trumps what. And so we have two different options for our clients that we offer that are worth mentioning here. And I imagine other attorneys in our practice area might be doing the same thing. One is a memo that we can draft for our clients telling them, here's where your documents conflict with WCIOA. So starting January 1 of 2028, here's what you have to do, here's what you can't do, and here are the conflicts you're going to be dealing with between the statute and your documents. And then the other thing you can consider is just doing a complete restatement of your declaration and bylaws. So there isn't a hard and fast recommendation for how often a community should revise its governing documents absent these types of really significant statutory changes. But I will say, setting up an annual task as a board to go through and review the documents makes a lot of sense to me, especially if as a board, you're kind of keeping your finger on the pulse of things like statutory changes, best practices, case law that might come out in Washington. And I think just by participating in this Q&A, you are definitely keeping your finger on that pulse. So Katie, did you have anything you wanted to add to that?
I would just want to highlight that even if you don't revise your governing documents to be compliant with WCIOA, you are going to have to change your practices. Yes. Across the board, especially with the new meeting stuff, no association is perfectly complying with what the changes will be right now. And so at the very least, you should know what you need to change, even if you don't want to take on the expense of restating everything. So the next question is, can an association give speed tickets or violation fines to members for speeding in the neighborhood? And this all depends on your governing documents. So we can't really answer this without knowing what your documents say and what your rules say. You have to be able to verify that a violation occurred, and the board has to do an investigation that's based on adequate information and objective inquiry to meet their statutory duty of care. So it might be kind of difficult unless you're sitting out there with like a speed gun to see how fast someone's going. I mean, yes, there are times if your speed limit's like 5 miles an hour and someone's zipping through the neighborhood, that might be different, but the violation has to be verified. Also, are the roads public or private? If the roads are public, you're going to have a harder time enforcing rules on any passerby. Are the violators members of the community or unknown persons passing through? Can you even tell who it is? If you have private roads and speed limits, then you can issue violation notices for exceeding those limits, but you can't just issue a fine sight unseen. You still have to give notice and an opportunity to be heard for the person driving through the community. You also may only be able to issue tickets to community members, not people who are visiting, especially if there's no posted sign or no way that they would know about the rule. And again, this all goes back to if you can even tell who they are. So the long and short of it is, maybe look at your governing documents. If you have a frequent speeder, it may be worth talking to your association attorney for how to deal with that and stop the speeding. Anything to add, Valerie?
I just want to emphasize that it's not a ticket, it's a violation, it's a fine. So the association isn't a governmental authority or a law enforcement authority with the ability to ticket someone. Your enforcement ability is limited to either fining the owner, if it's an owner, for the violation, or other options if that doesn't, address the situation and it becomes a really significant issue. So I'm persnickety about terms, and so I just wanted to emphasize that. All right, next question. Can we amend our declaration to prohibit real estate investors from purchasing units? Can we ban rentals altogether? So no and yes, in order. You cannot amend your declaration to prohibit entire classes of purchasers. And this is true even in a Housing for Older Persons Act community, a HOPA community. So in a HOPA community, you're allowed to limit residents who can occupy the units, but you're not allowed to say you have to be over 55 in order to buy within that community. And I think that part of what becomes difficult about all of this is how you define terms, right? However, you can absolutely amend your declaration to prohibit rentals. Typically, there is an exception or an allowance for close family members. And so if I owned a unit in a community and I moved into a retirement home and my daughter lived in that unit, that would typically be considered an exception to the ban on rentals. But I wouldn't be able to rent it to some random third party if you banned rentals entirely. I think some things that are worth noting is that if you are considering like a complete ban on rentals, depending on which type of community you are, your voting threshold is different. And in particular, new act condominiums probably have to get at least 90% of the voting power in the community to approve a proposed rental ban amendment. And in certain, if somebody outside of that 90% is also renting their unit, you might also have to get their approval. So in certain communities, what this effectively means is you have to get anywhere between 90 and 100% of the voting power in the community to support the amendment, just depending on the circumstances. For other communities, Wakiowa, for example, you could adopt a ban on rentals with a 67% voting threshold, unless the governing documents provide for a higher number. Some things to keep in mind if you're considering this type of amendment, but you're worried it might not pass, include that you could exempt current owners from the rental restriction or the rental ban, which might make it easier to get them to vote in favor of the amendment. This is also something that you can consider when, if you're in particular, if you're a new act condo and you're thinking about doing this, but you're not feeling like it's super urgent, this is something you could consider waiting for until Wakaiowa governs your community so that you could take advantage of that lower voting threshold. So, but under the Wakaiowa statute, Katie, correct me if I'm wrong, but I'm pretty sure Wakaiowa would essentially require that it not apply to current owners. Is that correct?
I think so, but
yeah, okay.
I want to confirm.
I'll double check that and correct myself next week if I'm wrong on this, but I'm pretty sure that is the case. So the short answer to the question is you can't prohibit real estate investors or any other specific group or class of people from purchasing within the community, but you can ban rentals. The only way you can do that is with an amendment to your declaration, because this is a restriction on use of the unit. And that kind of restriction belongs in the declaration or in an amendment to the declaration. Back to you, Katie.
All right, so our next question is, are there ways to lower the 67% approval requirement to amend our declaration? The short answer is no. No, the percentage requirement, at least in Ukiah, is set at a minimum of 67% and less than 90. So if you're a Ukiah community, you can't have 100% unanimous consent required to amend the declaration, but it also has to be a minimum of 67%. And this is in RCW 6490-285 subsection 1, I believe. There are two exceptions to this. So one exception is if you are a non-Ukiah community right now, you can't, and you say have 100% requirement to amend your declaration, you can choose to adopt Ukiah early with a lower threshold. And I think it's 67% of 30% of the owners in attendance at a meeting agree to adopt Ukiah. So whatever 67% of 30 is would be required to amend it. But then you are put into that 67% approval for everything else. The threshold or the ability to adopt Ukiah early with the lower threshold only applies to adopting Ukiah. You can't sneak in other changes to your documents with that. The other exception for Ukiah communities is the board alone can amend the documents to remove direct conflicts with Ukiah once that statute applies. So you could adopt it early so the board could remove direct conflicts, or you can wait until 2028 and the board, with notice to the owners that they're making these amendments, can adopt it without the 67% approval required. But there are no other options to lower your approval requirement for any other communities that exist. So basically, if your documents say 67%, you can't go lower unless you're trying to adopt Ukiah or the board is removing direct conflicts for a Ukiah community. Anything to add, Valerie?
Nope, I think you covered it. Excuse me. All right, next question. Section 16 of ESSB 5129, which is the Ukiah trailer bill that has now been signed into law, amends RCW 6490-445, subsection 2E, to read as follows. At each board meeting, the board must provide a reasonable opportunity for unit owners to comment regarding matters affecting the common interest community and the association. The board must provide at least 15 minutes at the beginning of each meeting for unit owners to comment about agenda items before the board votes. The board may place reasonable time restrictions of not less than 90 seconds per owner per unit, except that the time per owner may be reduced and allocated equally if more than 10 unit owners wish to comment. The question from the person who submitted it, I'm going to paraphrase because it's kind of long, is their community allows owners to comment at the board meeting before each individual board vote. And the question is, if they keep doing that, would they still be in substantial compliance with the intent of this provision of the law? My answer to this question is probably not. And it's not that you wouldn't be in compliance with the intent, right? But you wouldn't be in compliance with the actual plain language of the statute. The statute specifically says, and I'm going to go back and read it again. The board must provide at least 15 minutes at the beginning of each meeting for unit owners to comment about agenda items before the board votes. It is very specific, and it says must, and it says at the beginning of the meeting. And so I would not want to advise a client to do something different something different than what the statute very clearly says to do, based on a guess as to legislative intent. I do think that you're probably right. The legislative intent here was very clearly to give people, owners, the right to say things to the board before the board votes on the things that they're voting on. But I think the statute is very, very clearly written as to what that looks like. And you ignore that mandate and do it your way at your own peril with a potential risk for liability. In reality, if you are really effectively giving owners the right to comment before every single board vote, who's going to complain? Who's going to sue you and argue that you're not complying with the statute? Probably not going to happen. But it's also, I think, would be irresponsible of me not to point out that your way is technically not compliant with the plain language of the statute. That being said, you can do both. You can always give owners more time to talk than what the statute requires. And so you could have the 15-minute owner forum at the beginning of the board meeting, and also continue to give owners a limited amount of time before each vote if they want to say something additional to the board as you go throughout the meeting. In particular, if you are providing the agenda items to the unit owners before the meeting, or at the latest at the beginning of the meeting itself, they can comment on what they want at the beginning in that owner comment period that complies with the statute, and they don't need to be given another opportunity to comment before the vote. So I'm not sure that you need to do both, especially if the owners know ahead of time what things you're going to be voting on. So I know that's not the answer to the question that you wanted, but I think that is the correct answer to your question. Katie, did you have anything you wanted to add to that?
No, I think you covered it.
Okay.
All right. Our next question is, which bills has the governor signed into law? When do they go into effect? And which ones apply to all common interest communities? So as Valerie mentioned earlier, 5129 was signed into law by the governor last Tuesday. And for most of it, it is effective January 1st, 2026, except for some things that don't apply to all communities, which would then apply January 1st, 2028. But for Ukiah communities, they apply earlier. I'll get into some more changes, but basically, if you think it applies to you and you're a Ukiah community, the answer is probably. 1403, which has to do with condo liability, last I checked was still waiting for signature by the governor, but it is likely to be signed. And then 5686, which talks about the foreclosure and mandatory mediation, was, as of this morning when we looked, sitting on the governor's desk waiting for signature. So if you really care about that one, email info@condolaw.net to make your voice heard. Okay, so most of the changes you're going to see that apply to common interest communities are in that Ukiah trailer bill 5129. The big changes are to the meeting requirements, as we just talked about with the open meeting requirement. It also talks about emergency powers and when a board can maybe give less notice for a meeting than the I think it's 7 days. And it's pretty specific. It also requires that remote meetings have an option for telephone. It used to say an opportunity to comment and like be heard, but now it's specifically you have to give a telephone number. That one's not that hard because Zoom, Teams, Google already provide those. Board election ballots must have a blank space for write-in votes. There are some changes to the EV and heat pump charging policy or statutes. Another big one is secret ballots. So all ballots will be secret, and there's really specific language about who can see the ballots, and if an interested board member in the election can see the ballots, the short answer is no, and stuff like that. So if you're interested, you can go to the legislative website. I don't remember what the legislative website, type in 5129, pull up you can click a button that says what's the version of the bill that was sent to the governor, and it should have not a track changes, but an underline strikeout version for you to look at, and you can it's 83 pages, but you can scroll through and see what new things were added. There were not a lot of deletions, but there were some additions if you just want to scroll quickly to what those changes are. Valerie, do you want to add anything?
Just that I put a link to the session law, which is the one that will take effect, the one that was approved or passed, whatever. I just put a link to that in the chat. All right, I'm going to jump to our next question. Is it reasonable to require owners who lease their unit to submit a copy of the lease agreement to the association? I think it depends entirely on the circumstances and what your governing documents say. If the declaration or your rental amendment to the declaration gives you the right to request or require this, then it's probably reasonable to do so. If the declaration gives the board the right to adopt rules that govern leases, and you have a set of rules that requires this, then it's probably reasonable. And I think you can always ask, but that's different than your ability to require that they submit it and to find that a violation has occurred and to fine the owner for not giving you the lease if it's not provided. I also think that having a copy of the lease is probably less important as a practical matter than having information, for example, about the identity of the occupants of the unit, right? So it's probably, as a practical matter, more helpful to the association to know that there are 4 people living in that unit and their names are fill in the blank and the cars that they drive are fill in the blank. So a lot of our clients, rather than requiring a copy of the lease be provided to the board, will require that a resident or like an occupant information form be filled out and provided to the association, so that if there's an emergency and you need to reach the occupants of the unit, you have contact information, stuff like that. I think taking a step back, it's important to say that the word reasonable is one that we use all the time when we are trying to guess how a judge is going to view something. A judge in the future is going to look back on an association's actions and try to determine if those actions were reasonable, because all actions that an association takes have to be reasonable. Unfortunately, reasonable is not a bright line. There's not a dictionary definition there is a dictionary definition, but that's not the one that judges use when determining whether an association action is reasonable. It depends on the circumstances, it depends on the community, and it depends on the governing documents. So we can't give a definitive answer to this question. And if you need one, then you should be contacting your association attorney, who can advise you on whether it's reasonable based on your specific circumstances and governing documents. Katie, did you have anything to add to that?
The only thing I'll add is that, and we get this question a lot of, basically, can the association enforce provisions of the lease? And generally, if the lease is between an owner and a tenant, the association isn't even a party to that lease. Right. So yeah, you could have a copy of it. Your documents may even require that you be given a copy of it, but that doesn't mean you can do anything with it. And so how much is it really worth? You can't enforce lease. You can enforce your rules against the tenant, but not the lease. You can't evict them unless there's a bunch of other factors. So it might not even be worth the fight. Okay, next question is, how are reasonable fine amounts determined? And as Valerie said, there's no bright line for what reasonable is, but the board initially gets to determine what is a reasonable amount for the fine, given the nature of the violation and the community. Reasonable is determined by a judge of what a reasonably prudent person in a similar situation would think it is. And this, like I said, is ultimately determined by a court for the specific circumstances. So you could even be in the same community, and what's reasonable for one person for one fine may not be reasonable for someone else. It is determined after the fact if it's challenged by a neutral third party, the court, or sometimes an attorney trying to collect on the fines. It's often harder to say what is reasonable, and it's easier to say what is not reasonable. So we can say that a $15,000 fine for having an orange door, probably unreasonable, but a $50 fine for a pet violation on the first one, that might be more reasonable, but we don't know. What if the pet's only 1 pound more than the weight limit or whatever? There are a lot more factors. We often have collections matters come to us with thousands of dollars in fines that we have to tell the client we will not try to collect because we can't collect something that we consider unreasonable. We usually see this with frequent reoccurring daily fines. Those add up really quick, and the higher the dollar amount, the more likely it is going to be unreasonable. And so that's something to consider. Not that you don't have the right to enforce them, we just can't collect on it. Fines may relate to the cost incurred by the association for a violation. That may be a way to make it reasonable, or may relate to what is required to deter the behavior involved. There's no hard and fast rule, but as long as you can articulate a reason for the fine, it's more likely to be reasonable. So not just, oh, I picked it out of the air, but this is what it costs to, as an Airbnb, like this is how much they were making in violation of the rules. That may be more reasonable than $500 because I feel like it. Anything to add, Valerie?
Yeah, I will add 2 things. One is you have to have a specific schedule of fines that is adopted by the board and published to the owners before you can levy a fine against anyone for anything. And 2 is that schedule should not say that fines are at the discretion of the board in an amount that they get to determine, because that, I don't think, satisfies the statutory requirement that that schedule of fines be posted to the owners in advance so that they know what it is they're risking if they violate the association's rules. I also see a really big problem with failure to give proper due process in fine notices. And for those of you that have been coming to this Q&A for a while, you might be sick to death of hearing us beat this drum. But the reason that we continue to beat the drum is that every time we have to tell a client that sends us a collection matter, sorry, I can't collect this fine, it's not enforceable, I would say 8 or 9 times out of 10, it is because of a failure to give correct due process in the notice of violation. So you guys can maybe put some comments in the chat if you think it would be helpful for us to have a little primer at some point, like take 20 minutes at the beginning of the Q&A to walk you through what is required to levy enforceable fines, and we would be happy to do that. The other thing that I will offer is that, you know what? I just had a thought in my head and it went away. So I'll come back to it later if I remember. I don't want to delay us going through the rest of the questions. But I think that covers it for that. And I'll come back to that thought if it comes back to me. So, all right, here's our next question. If there is a rental cap amendment vote currently in progress, and the original mailer included a ballot submission deadline of March 31st, can the board decide to extend this deadline provided that notice is given to the owners via email? Okay, so part yes, part no. The statutes do allow the board to extend the voting on a proposed amendment for a reasonable time not to exceed 11 months if notice is given to the owners, but you have to send notice in the manner that is required by the governing statutes and your documents. And that does not include email unless the owners have opted into electronic notice. So it is not good enough to just send an email unless every single owner in that community has agreed to electronic notice. It's reasonable, totally reasonable to send it by email and regular mail, but the notice provisions of our governing statutes, and this is true for all of the common interest statutes in Washington, provides that notice has to be given by mail. I think, UPS is fine, regular mail is fine, whatever, unless an owner has opted into receiving electronic notice. And in that case, you can give them notice by email. There is a process in the statutes that talks about how to extend the voting and what you have to do. And if you want to look at an example of that, you go to 6434-340, subsection 6, and it's the same language in all the statutes, and it walks you through the process to extend the voting. And then one other thing to keep in mind is that you are required to allow owners to change their vote during any extension of the deadline. So if an owner casts their vote one way and then comes to you a month later before the voting is over and says, I want to change my vote, you don't get to tell them no. You have to tell them yes. The other thing to keep in mind is that if during the extended voting period, a unit owner sells their unit, you have to get a vote from the new owner. You can't count the vote from the old owner because they're no longer an owner by the time the voting deadline comes. Katie, did you want to add anything to that?
The only thing I'd add is you can also, and what we do with our draft ballots is put a little blurb or a sentence in the ballot in addition to the notice that you send out, that the board may extend the deadline to receive the number of votes required to pass the amendment, just so everyone is aware from the get-go that the time may be extended. All right, so the next question is it required for an HOA to have a reserve study completed for the association if the only shared common elements are mailbox clusters? So this is going to depend, again, on your community. This is not legal advice, but one section to look at that may answer your question is RCW 6490-545, which applies to all communities of any age. Subsection 2 says, unless the governing documents require otherwise, the reserve study requirement of this section does not apply to common interest communities containing units that are restricted in the declaration for non-residential use, to common interest communities that only have nominal reserve costs, or when the cost of the reserve study or update exceeds 10% of the association's annual budget. So reserve studies are only required for communities with significant reserve costs. If the cost of the reserve study exceeds 10% of the annual budget, you're also exempt. This would mean, typically, yes, if your mailbox clusters or whatever are not a significant reserve cost, or the study would exceed 10% of the budget, you would not have to do the reserve study. Anything to add, Valerie?
Nope, that covers it. All right, next question. RCW 24.03A.575, subsection 5D, which is part of the Washington Nonprofit Corporations Act, says that committees of the board may not elect, appoint, or remove any member of any committee of the board. If the committee of the board has non-voting members that are not directors, in addition to the 2 or more directors on the committee, does this statute disallow that committee from choosing its own non-voting members? And if so, could the board by resolution allow committees to select their own members? So the answer to this question is no, it does not disallow the committee from choosing its own non-voting members. The board appoints non-voting members to a committee and can remove them with or without reason. The charter of the committee could allow the 2 board members that are part of the committee to select their own members. The statute itself is silent on this question, but we don't know why it couldn't be done. We're also unaware of any cases that have, clearly defined the answer to this question, one way or the other. So if a committee wants to choose members, they should ask the board to appoint them. The board is the entity that gets to choose all the board members that are members of that committee, if that makes sense. So if you look at 6490-410 subsection 6, it says, except for committees appointed by the declarant pursuant to special declarant rights, all committees of the association must be appointed by the board. That is from Wakiowa, which is going to be applicable to everybody pretty soon here in 2028. And anytime there is a conflict between the common interest statute and the nonprofit statute, the common interest statute controls. The nonprofit corporation statute is essentially it's like a fill in the blank statute for our type of communities. And so given the specific wording in Wakiowa, which says committees of the association must be appointed by the board, we think the least risky course of action is for the board to be the one that appoints committee members. Katie, did you have anything to add or want to clarify anything there?
No, I think you covered it. Okay. So the next question is, until House Bill 5129 kicks in, RCW 6438 has little to say about committees. Our board has interpreted 6438.045 subsection 4B to mean that the ARC committee simply keeps a record of its actions as opposed to holding open meetings and taking minutes. Is that a defensible interpretation? As we usually say, we would need to review your documents to know exactly what to tell you. Documents have very specific language about what authority an ARC committee or an ACC committee or whatever acronym you want to use has, and whether or not they have to have open meetings or take minutes, or if they can even actually make decisions, or if they're advisory only. If your community under 6438, you have an open meeting requirement right now for the boards, in general. I would suggest or argue that you have an open meeting requirement for any committee exercising board authority, as is the intent in Ukiah. So if your ARC is exercising board authority, even if you're a 6438 community, you probably have an open meeting requirement, and we would recommend open meetings for your boards. Any committees exercising board authority, whether it be an ARC or the actual board, should be open and should have minutes. The minutes reflect the action taken. The minutes are the record of the action taken. So whether the interpretation in the question is defensible in court would depend on many factors, and we would need all the specifics to give legal advice on the matter. But the open meetings are coming. You can just embrace it now because they're not going to go away. Anything to add, Valerie?
I agree with that last statement wholeheartedly. All right, next question. I would like to know, when the board revises the House rules, whether an attorney needs to review them before they are published to the homeowners. There is no statutory requirement that your association attorney review the rules, but I would strongly recommend it. Now, it probably depends on the type of revision we're talking about. If you have a set of rules that were drafted by your attorney or that have been reviewed by your attorney, and you're making minor revisions like changing the quiet hours from 9 p.m. to 10 p.m. or something like that, that is not a change that requires probably a review by your legal counsel. But if you are making anything that would be considered a substantive or significant change to the rules, you should at least have your attorney review them to make sure that they are not in conflict either with more powerful governing documents like your declaration or bylaws, and also to make sure that they're consistent with or don't conflict with current statute. And especially those of you who have been here for a while know very well, we've had really significant statutory changes in a number of different areas in the last 5 years. It feels like sometimes hard to keep up with some of these statutory changes, right? And if your board adopts a set of rules without knowing that the rules run afoul of a particular statute or are inconsistent with the declaration, that is the kind of thing that your attorney would catch if you sent the rules to them for a review. So I think it's a good idea to have an attorney review them to make sure that they're enforceable, that they don't conflict with your declaration, that they're reasonable, and also that shifts risk and liability from the board to the attorney if something in the rules slips by that is unenforceable or that is a mistake. The other thing I want to remind everybody, which is not directly responsive to the question, but that is going to be true for all of us very soon, under Wakiowa, any change to the rules, and this would include things like your collection policy, your fine and enforcement policy, if you have a communications policy, any change to the rules, you have to now send it out to the ownership and give them an opportunity to comment on the proposed change before the board can then vote to adopt the rules. So this is not true for non-Wakaiowa communities yet. Non-Wakaiowa communities still have the ability for the board to adopt the rules unilaterally and just publish them to the owners, and they are then enforceable. But in the spirit of sort of start practicing now, because this is going to apply to all of us soon enough, you might want to start getting into the practice of sending the proposed revised rules or policies out to your owners, giving them 30 days to comment, telling them ahead of time, at the board meeting on May 2nd, we're going to vote on these rules. And then the board votes to adopt the rules. And then you have to publish the adopted enforceable rules out to your ownership at that point as well. In particular, if there's any change, but also, I mean, just either way. Katie, did you have anything to add?
Nope, because anything I'll add is in our next question.
All right.
So I have a question for your team concerning transition to Ukiah. Background. Our association is 50 years old and governs over 600 homes. Our APPs, which we think mean association policies and procedures, span 50 to 60 pages across our standing committees and more if we include non-board committees and legacy policies. So the question is, must HOAs readopt these APPs using the Ukiah compliant rulemaking procedures outlined in 6490-405 in order for them to remain enforceable after January 1st, 2028? If so, do you have a sense of how other common interest communities are approaching this? Short answer is no. You don't have to readopt anything for it to be enforceable under 6490 when it eventually applies to your community. This means that anything that exists, as we talked about in the last question, continues to exist unless there is another conflict. So sections that are prohibited by Ukiah in your current policies will not be able to be enforced. But anything that is not prohibited is still good. Internal operating procedures need not be adopted as rules per RCW 6490-505 subsection 4, I think. But that says, that's the rule section, and it says an association's internal business operating procedure need not be adopted as rules. So you can, I would not include your fine and enforcement policy as that. I think that means how we're going to adopt the meeting minutes or something much more internal than things that impact owners' rights. So how you approve an ACC application might be more internal. You can always let owners comment on things, even if the statute doesn't require it. But you don't have to for internal business operating procedures. So as I said, you don't need to republish rules and allow owners to comment on them if they're existing. The same rules that existed before January 1st, 2028 will still apply. So a collection or investment policy that's in place could still be enforced. You only need to give owners an opportunity to comment if you're changing the rules after January 1st, 2028, unless your documents currently require something different. So some documents already require that rules be sent to the owners for an opportunity to comment before they're adopted. Even if you're not a Ukiah community, you still have to do that. And as I said, if your pre-2028 rule conflicts with the statute will prevail and your conflicting rule will not be enforceable. For example, if you say no beehives, that is a conflict. You have to allow beehives or any pollinating habitat. Valerie, anything to add?
Not on this topic, but I remembered the thing that I forgot earlier when we were talking about rules, which was I see a lot of fines for failure to water the lawn because the lawns get browned out and, you know, folks are trying for uniformity within their community. And as Katie will tell you, Washington State has a statute that prohibits HOAs from enforcing regulations, requirements, rules, whatever, that have to do with watering if there is a drought declared by the state. So this is something that, here we are, April 30th. My lawn is still pretty green right now, but it's coming. The brown is coming, everybody. And so as we head into this summer and your board might be, let's say you're a manager and you've got a board that's like, you need to send violations to all 17 of those lots that have really brown lawns. As a manager or as a board, you all should be aware that if your community is in a location where the state has declared a drought, you are not allowed to enforce watering related landscaping rules. So you can still require that they, mow the lawn and weed whack and not leave their, lawnmower in the middle of the front lawn, things like that. But you cannot enforce rules that are about keeping the lawn green or otherwise watering people's landscaping during a drought declaration. That's what I was thinking of earlier today.
Just as a quick addition, in 2024, because I looked it up, in 2024, the only places in the state that were not in a declared drought by the Department of, I think, Ecology were Seattle and the surrounding like 5 cities, like Everett and a little bit of Snohomish County and Tacoma. Not even like even places in like eastern King County, eastern Pierce County, eastern Snohomish County, all drought. The entire map is orange. So just be careful unless you're in like Seattle, Tacoma, or like Everett.
Yeah. And if you don't know how to look this up, you can totally email your association attorney will be able to tell you how to look it up. You can also just Google, Washington State Drought Declaration 2025, and that will take you to the website where you can find out where a state of drought has been declared.
And I would expect, given our dry winter, that
yeah,
we might have another one.
Agreed. All right, next question. We have rules that require subjectivity to interpret. At a minimum, do these rules require attention to be compliant and enforceable under WCIOA? I'm going to start by saying I don't really know what this person is asking. And then I'm also going to say that I think maybe part of the question is, should we have a lawyer review them to make sure that they're not inconsistent with WCIOA? And if that's the question, then I think we already answered it earlier. And in particular, what I'll say is if you've never had your rules reviewed by an attorney, then that would be a really good idea to get that done, regardless of the WCIOA situation. And I think we've talked so much about rules today that I'm going to leave it at that unless somebody wants to provide some clarification into the chat as to what this question is about. So take it away, Katie.
Next one is, what specific RCWs state the start date of WCIOA for all, or when all the other RCWs for present common interest communities get deleted or canceled? So your best current source of all this is going to be the current bill 5129, but RCW 6490 365 says what provisions currently apply to all communities. Note, it has not been updated with the changes that were just signed into law, so that list will be updated at least on the website in the next few months. RCW 6434 076, 6432 260, 6438 095 all say what provisions of 6490 apply to the association. So it's basically a cross-reference back. But nowhere does it say in the statute that they all expire or deleted. It's all over the website. It's in big bold, this is going away January 1st, 2028. It's even in little notes that says everything will expire. And the bill from last year, which was the original WCIOA for all bill, says that RCW 6432, 6434, and 6438 all expire January 1st, 2028. So you can look there. It's everywhere. And then there's another reference for 6490.090 if you really are interested. Did I miss any reference, Valerie?
I think you got them all. All right, next question. if an association has a rule about no RVs, trailers, or boats within the community, can this be enforced if they are on public roads? So, lawyer answer, it depends. Generally, the association has no authority to regulate how public roads are used, no authority to enforce private restrictions on public roads. But the association can govern the conduct of owners within the community, even if there are public roads within the community. And so you would need to know for certain that the RV, trailer, or boat or whatever belongs to an owner in the community and is being kept in violation of the rules. But this is a very, I'm like answering this question with a lot of caveats because it depends a lot on what the governing documents say and the specifics of what the rule is. Also, the specifics of what the owner is doing are. If the owner is violating city code, that is something that can be reported to the city or the fire department, and they can take action to enforce, like if they're blocking a fire hydrant or parking too far into the street or whatever. And some cities have prohibitions on the same kinds of vehicles and will enforce those. So that's something that you could look into if this is something that the community feels really strongly about. But otherwise, I hate to do it. I feel like we do it so much, but it really does depend on the specifics of, where your community is located, what your local ordinances say, and what the governing documents for the community say. Katie?
Nothing to add. I'm going to take us to our second to last question, and we may be able to get through them all. Does 6490 intentionally exclude common elements with an expected life of over 30 years from the reserve account use? And was there an intent behind that? Does the legislature not want us to use a reserve account for such an element? And what did they think we would do instead? So as you can tell, I shortened that question. There was a lot more backstory. In summary, the original question was referring to 6434 and the difference between 6490. So 6434's definition of a reserve component does not include a time limit for when something is considered a reserve component, while 6490 only requires that items with a lifespan of 30 years or less from the date of the study be included in the reserve study. And I'm just gonna say right now, we don't know what the legislative intent was. I'm not even gonna try and guess. We don't even know if the change was intentional or not. So it is unlikely that the legislature cares that components with a useful life of over 30 years be included or not. And it's possible that they were giving the associations an out for having to include items over 30 years. We think, if we were guessing, they intended that if an expense would be incurred over the next 30 years, it must be included. So if you have a 50-year item, they would join the study when they are 20 years old. Some items, I think the example was like a retaining wall, which has a life of 100 years. So that would be included at year 70, which you'd have to track. It's also possible that the intent was to focus association reserves on big ticket items like roofing and siding and make sure that money is prioritized. You can always add components to your reserve study, even if the useful life is more than 30 years. You can always do more than the statute says, just never less. Anything to add, Valerie?
Nope, I think that covers it. And I'm going to dive into our last question as quickly as I can. This was a very long question about how boards, as characterized by the person asking the question, sometimes, but not always, try to wiggle around the enforcement of rules or handling infractions and fines. And we're going to boil the question down to, when can the board stop finding violations, and what ability does a board have to modify the rules? Or to decide they're not going to enforce a specific rule, right? I think what it always boils down to, and something you've heard us say here before, is that rules must be enforced uniformly. You need to treat all of your owners the same when it comes to enforcement of any particular rule. And no owner is entitled to special treatment because they're on the board, or because they're best friends with somebody on the board, or because they're married to somebody on the board, or anything like that. By the same token, you shouldn't enforce rules against one owner that you don't enforce against others because you don't like that person, or even because they're problematic and high effort and, you know, they criticize the board all the time. So again, uniform enforcement of the rules. There are circumstances that could distinguish one owner from another if the board has a reasonable basis to vary from uniform application of a rule that might be permitted. And if you're thinking about that, you probably should consult with your association attorney. And then even if an actual violation has occurred, the board can determine that enforcement action is not in the best interest of the community. And so if you look at 6490-405, subsections 7 through 9, that is currently applicable only to Kiowa communities, but you can certainly use that as guidance to determine that taking enforcement action is inappropriate or not in the association's best interest. So I think that I'm going to leave it at that because we are at 11 o'clock, but the person who submitted this question, if you would like us to dive deeper into this, feel free to let us know with an email. And thank you all for joining us today, and we will see you back here next week. Bye, everybody.